first information report is a basic and fundamental document for every criminal proceeding. It is basically the information relating to the commission of any cognizable offence, and it needs to be reduced in writing under section 154 of Criminal Procedure Code. The method to register the FIR is very simple, that is enshrined in Code of Law. There are two modes of registering an FIR. It could be through oral means or it could be through written means. The oral means means that any person, any informant who is going to give the information regarding commission of an cognizable offence, first of all, these procedures need to be followed. First of all, his oral information is to be reduced in writing, and then it is to be signed by the informant who is giving the information, and then it is to be read over to the informant, and then finally it is to be entered into the register that is maintained for the FIR in its substance. The contents of the FIR have two important columns. First of all, it says that date, time and place of the commission of the offence, and then it is followed by the date and time of the information that is being given. I mean to say that the FIR, when it to be registered, then you need to mention the reason why there is delay. But if the delay is justified, there is legally speaking, there is no time limit as to when is the FIR is going to be registered. The complainant may name anybody because it is the first information report. It, as I told earlier, that it is neither a piece of substantive evidence or nor it is exhaustive document. So he may name anybody who he wants, but there is immunity given to certain individuals while they are in office. In our constitution, they are barred from any criminal proceedings. Otherwise, he may name anybody he wishes. Principally speaking, there is no evidence that is required to name any suspect. The collection of evidence is basically the prime responsibility of the investigation officer, who is entrusted to investigate the case under section 156 of Criminal Procedure Code. Once the FIR is registered under section 154 of Criminal Procedure Code, the evidence then collected after the IO starts his investigation, it may or may not support the version of the informant or the complainant, so to say. The police cannot deny the registration of an FIR. It is their mandatory responsibility, and it is statutory responsibility of the officer in charge of the police station. When any information relating to the commission of a cognizable offence is communicated to him, he is bound to register the FIR under section 154 of CRPC. However, if the information is related to the commission of a non-cognizable offence, he may enter, or he is required to enter the substance in Roznamcha and then communicate the same with the magistrate. The Police Rules 1934, it also empowers the investigation officer, or so to say the in charge of the police station, that he may, if he suspects that the information given to him is of suspicious nature, then he is required by law to reduce the same in writing, and then he needs to give the reasons for that, and then it is his duty to inform the informant as well, and then the station diary in which he has written that, it is need to be circulated to his superiors and the magistrate, and afterwards if they think that the case needs to be registered, then they may order to register the case.